8 p.m. Nairobi. My name is Vincent Odundo. My sign language interpreter this evening is Moses Gitonga. Let's keep you updated on the big and developing stories of the day. And we start off with news that the High Court has dismissed the case by the LGBTQ community that sought to repeal sections of the Constitution that criminalize sex between individuals of the same sex. A three-judge bench led by Justice Chacha Mwita, Justice Joseph Mativo, and Justice Roslyn Aburili thwarted the case on the basis that it lacked sufficient evidence and had no basis.
The quest by the lesbians, gay, bisexual, transgender and queer community to repeal Section 162 of the Constitution that criminalizes gay sex was today unanimously thwarted by a three-judge bench on claims that it lacks sufficient evidence to support their basis and had no merit. Justice Chacha Mwita, Roslyn Aburili, and Joseph Motivo ruled that the petitioners represented by Senior Counsel Paul Mwite failed to convince the court on their basis of argument.
Sex unions, we find it difficult to agree with the petitioner's argument that we can safely nullify the impugned provisions whose effect would be to open the door for same-sex unions and without further violating Article 159, Subarticle 2E of the Constitution, which enjoins this court to protect and promote the purposes and principles of the Constitution.
Where a party cites articles of the Constitution alleging that they have been violated, he or she is duty-bound to adduce convincing evidence to prove the alleged violations. In this case, save for the allegations made in the petition and the affidavit, no tangible evidence was given to support the allegations. No evidence was tendered to establish any of the cited acts of discrimination, so our finding that there is no basis at all upon which the court can uphold any of the alleged violations. In the end, we find that the petitioners have failed to establish that the impugned provisions are discriminatory.
The petitioners of the LGBTQ community had sought interpretation of Section 162 and 165 of the Constitution. The gay community activists told Justice Rosina Burile, Chacha Mwita and John Mativo that gay feelings are natural and the state has no business intruding into their private matters of two consenting adults. But religious groups, through their lawyer Charles Kanjama, argued that such matters should be guided by the country's values. The three-judge bench claiming that the interpretation of Section 162 and 165 of the Constitution should be strictly within the context of the cultural values and principles of the country.
The first is that the context as here used is not limited to the language of the rest of the statute regarded as throwing light to a dictionary kind on the part of to be interpreted. Often more important is the matter of the statute, its apparent scope and purpose, and within limits its background, end of quote.
And the law, we are not satisfied that the petitioner's attack on the constitutional validity of Sections 162 and 165 of the Penal Code is sustainable. We find that the impugned sections are not unconstitutional. Accordingly, the consolidated petitions have no merit.
Justice Roslyn Aburili further elaborating that no scientific and substantive evidence symbolized that indeed the individuals in the lesbian, gays, bisexual, transgender and queer community were born that way.
We are unable to agree with the petitioners that the views of Kenyans should be ignored given the clear and unambiguous provisions in Article 45, Subarticle 2 of the Constitution.
It is a disappointing day for the LGBTQ community after the High Court declined to repeal Section 162, which criminalizes gay sex. However, the battle is not over after their lawyer Paul Mwite threatened to move to the Court of Appeal. Irene Mwangi, KUTV, Nairobi.